This is Ask Todd on the Financial Exchange Radio Network. If you have an existing estate plan or are in the market for one, Todd Lutsky is here to answer your questions and help you plan for later life. Ask Todd is presented by Cushing & Dolan, serving Massachusetts and New England for more than 35 years, helping families with estate and tax planning, Medicaid planning, and probate law. Visit CushingDolan.com. Now, here's Todd Lutsky.
As promised, we're now joined by Todd Lutsky from the law firm of Cushing & Dolan. The segment is Ask Todd, and it is your opportunity to ask Todd your estate planning questions. Phone lines wide open right now at 888-205-2263. We can normally get through about 2 to 3 calls. So, if you got a call, make sure you get in early so that we can get to you. 888-205-2263. Again, this is your opportunity to ask Todd Lutsky your estate planning questions live on air. 888-205-2263. One more time, that number is 888-205-2263. Mr. Lutsky, how are you doing today?
Never better. How are you?
Pretty good.
Uh-oh.
I got a question for you.
Yeah?
What do you call a monk who walks everywhere in bare feet, has poor bone density, and really bad breath?
That's a lot of things. I can't even think of all those. I can't even follow this, so I'm just going to say I don't know.
A supercalist fragile mystic hexed by halitosis.
Wow. That's
good.
It's
wild.
That is wild. I can't even remember that.
Let's talk a little bit about estate planning. When we talk about someone who's maybe at the beginning of the estate planning process, probably a little bit intimidated. How do they decide which estate planning tools are actually the right ones for their specific situation?
So a couple of things. When we talk about it, I always like to, this is why we call it, the guide is back to the basics, right? It's thinking about how do we get started. I would say the very first thing you should do is take a look at your assets and value them. Figure out what it is you own and what you roughly think it's worth, because it's the value of the estate that really drives the type of estate plan that you're going to do. Okay, so let me try to expand on that a little. You know, when I say how you own it, right? If you own it, it's an asset. It doesn't mean it's a probate asset. It just means that it's a gross estate asset. Very different. You could have 0 probate assets, but all are still part of your gross estate. I think the bigger question is, when I say value it, intuitively, what am I valuing, right? What is included? Not everybody thinks about this, right? But obviously your bank accounts and your brokerage accounts, that comes to mind, right? Because it's money, and you say, yeah, I feel it, I see it. You know what they don't think about? Real estate. They say, oh yeah, I got $1 million home. Oh, but I don't feel like I'm worth $1 million because it's real estate. You know, I don't count that. Oh, but the government does. So you got to count that as an asset of the estate. Another thing people don't think about, Roth IRAs. They'll say, oh, you know, Roths are income tax free. Well, yeah, they are, but they're estate taxable when you die, so please count them. You know, even regular IRAs, they are, estate taxable when you die, so please count them as part of your estate. And you know, one of the other things that almost everybody forgets, life insurance, right? Oh, life insurance, isn't that income tax free? Well, it is, yeah. When you die, if your spouse gets it, it's income tax free. And never mind a spouse, whoever gets it, it's income tax free to the person who gets it. But the government values everything right when you die. The moment you die, that's when they value it. Because you might say, well, you know, I got this term insurance policy and it has 0 cash surrender value today because I'm living. The next day I die. Well, it's worth $1 million if that's the face value. That's when the government values it. So now, one item, right? You could be sitting here saying, well, geez, I'm not worth $1 million. Oh, wait, I have $1 million life insurance policy. You're all of a sudden worth $1 million and you haven't talked about any other assets yet. That one asset could put you at $1 million.
Talking with Todd Lutsky from the law firm of Cushing & Dolan. Again, the segment is called Ask Todd because it's your opportunity to ask Todd your estate planning questions. We do have space on the phone line still at 888-205-2263. 2263. That is the number to call to ask Todd your estate planning question live on air. Again, that number is 888-205-2263. We're going to take a quick break right now, but when we come back, it's going to be right to your calls with Todd. That phone number is 888-205-2263. One last time, 888-205-2263. Your calls with Todd when we return.
Ask Todd with Todd Lutsky every Wednesday at 10:30, only here on the Financial Exchange Radio Network. You're listening to Ask Todd with Todd Lutsky on the Financial Exchange Radio Network.
All right. Let's get right to your calls with Todd Lutsky. First in the queue, we've got Mike from Drake. Mike, what's your question for Todd?
I have a grandfather who passed away.
Uh-huh.
He left everything in his will. Basically, is coming to me and my wife.
Okay.
There's only one thing. There was a bank account that was left in a trust to my father-in-law. My father-in-law had passed before my grandfather had passed away. My grandfather had dementia. My question is, where will that money go now that was in that trust from Bank of America? Will that go back into my grandfather's estate, or does that go to my father-in-law who remarried another woman?
Okay, so you just added a third factor that really threw me off. So let me just try to recap, and please try to help me when I ask you these questions. So the first one is you're the grandchild of the grandfather who died and left a will, leaving assets to you and your wife. So that piece is clear, right? We understand that went to you, right?
Yep.
Okay, that's not an issue. In addition to that, you said that your stepfather or no, your father-in-law.
My father-in-law.
Your father-in-law had a trust in place, a bank account in a trust, or did the account say in trust for?
In trust for.
So there was no actual establishment of an actual trust. It just simply is more of a designated beneficiary on the account, correct?
I believe so.
Okay, so it said in trust for who?
It would be his name, Harry.
No. So who's Harry's not the father-in-law, right?
Yes, he is.
So the father-in-law had an account and the account said, when I die, when father-in-law dies, the assets in goes to who?
When grandfather passed away, it would go to. The trust was in the grandfather's, and when he passed away, it went to my father-in-law, which my father-in-law had passed away before my grandfather.
Okay, so now I'm just trying to get to the bottom of this, right? This is what's complicated about a lot of these questions. So grandfather, again, had one bank account that had in trust for father-in-law, correct?
Correct.
And father-in-law died before grandfather.
Correct.
Okay, and that account still existed when grandfather died.
Correct.
And so if it said in trust for someone who's deceased and there was no alternate beneficiary listed, then what happens is that would end up in the probate estate of the father-in-law. So, I'm sorry, not of the father-in-law. It would lapse as to the father-in-law. It would end up in the probate estate of the grandfather. So then the grandfather would die owning an asset with no beneficiary, but in his name. So his will should direct where that goes. So then that would end up going to you because his will said everything that's a probate asset goes to you. Remember, that item initially would not have been a probate asset because of the designated beneficiary listed. That's what keeps it out of probate. But if that beneficiary does not exist, then it's as if there is no designated beneficiary, so then it would end up a probate asset. Now his will says where it goes. So I think it goes to you, you and your wife, if his will says, I leave all my probate assets to my grandson and his wife. So there you go. That's my answer, and I think that's where it's going to go, but you might have to do some probate work for your grandfather's estate. Folks, lots of stuff going on in a question like that. And again, I think it's partly because of the lack of planning that was done, right? If you don't do your planning, you run into these kinds of problems. Learn how to do your planning. Get the guide, Back to the Basics. It's basically a recommendation. It's my engagement letter to a made-up family with a bunch of assets. And it talks about the will, the health care, the power of attorney, the HIPAA. Really explains documents that we always give a cursory example of what they are. And it also, you can put your fact pattern with this and learn it. In this one, it recommends an irrevocable trust or two for this family. See if this recommendation works for you. If not, learn by getting the guide. It will at least teach you how to begin thinking about getting your estate plan in order. One of my favorite guides, folks, 866-848-5699 or legalexchangeshow.com. Back to the Basics, 866-848-5699 or legalexchangeshow.com.
Todd, I've got another caller for you here. We've got Steve in Bridgewater. Steve, you are on with Todd Lutsky.
Hi, guys. How you doing?
Great. You?
All right, doing good. Hey, life estate. My mother had a life estate. I was the remainder man.
Okay.
She passed away in 2024.
Mm-hmm.
For cost basis, would I do a cost basis when the life estate was first created or when she passed away?
Do you still own the house or did you sell it?
Sold it already.
So you sold it. When did you sell it?
In December of 2024. She passed away in April of 2024.
Okay, so that's why I needed to know those specifics. So here's the answer.
Uh-huh.
One, the house, I'm going to expand so people understand, first of all, what is a life estate, right? A life estate is when you give something away, like a house, your primary residence, please don't do it with any asset, and retain the right to live there, right? So by doing that, retaining the right to live there, you avoid probate when she dies, and you've protected it from the cost of long-term care. I don't love the arrangement because there's a lot of negatives that go with it, but in this case, we don't need to go down that road because mom has passed already, so none of the negatives happened. So we now, though, by keeping that retained interest, that right to live there, that causes that asset to be included in mom's estate on the date of death. So in April of 2024, the full value, not just the value of the life estate, but the full value of the property needs to be included in her gross estate, not her probate estate. So it's not a probate issue, to determine whether or not an estate tax return is due. So on the date of death, April, what do you think that house was worth, Steve?
$450.
Okay, so if we've got a $450,000 value on the house, that means that the cost basis to Steve is $450,000. Now, between April and December, this may have increased in value. How much did you sell it for?
$440.
Oh, even better. So in this case, you cannot generate a loss. I know as much as you might be thinking, that's great. No, you can't generate a loss. But in this case, you will have zero gain to report on your income tax return, right? Because when you report it, you'll show the sale 440 or for 440. You'll show the cost basis of 440. And by the way, when you say you thought it was worth 450, if you sell it within 9 months of the date of death, roughly where you are, even within a year of date of death, it's the sale price that is the cost basis. So in this case, you've got to step up in basis. Your cost is 440. Your proceeds are 440. Your gain you report as zero, and you keep all the money. No federal, no state death tax. So that's how you calculate cost basis in a situation like this. And that's a great thing to have, folks. Whenever you're dealing with real estate, you always want to think about not giving away an asset like that and keeping it so that when the beneficiaries get it, in fact, if they don't want it, they can sell it and not have the capital gains tax to pay. And if it happens to be a rental property and you get a step up in basis and you keep the property, then you have the ability to offset the rent through depreciation over the next 27 and a half years. So wonderful thing, step up in basis, folks. Learn about step up in basis also in the guide.
Mr. Lutsky, thank you for joining us today.
Always a pleasure.
This has been Ask Todd on the Financial Exchange Radio Network. Ask Todd with Todd Lutsky has been presented by Cushing & Dolan, serving Massachusetts and New England for more than 30 years, helping families with estate and tax planning, Medicaid planning, and probate law. Call 800-393-4001 or visit CushingDolan.com. The views expressed in this segment are solely those of Cushing & Dolan. Armstrong Advisory does not provide any legal or tax advice. Please consult with your legal or tax advisor on such matters. Cushing & Armstrong do not endorse each other and are not affiliated.